Chapter 1 and 3. What does a principal need to know about special education law? What does a principal need to know about special education eligibility? The Individuals with Disabilities Act, IDEA. The foundation of this initiative is the federal law that states that every child with a disability is entitled to a free and appropriate public education, FAPE. The original title was the Education for All Handicapped Children's Act, 1975. This sent the message that no child was to be excluded educationally, no matter their needs. The idea of IDEA is the foundation for all special education and all modifications going forward. Identification, evaluation, and placement. Identification. Everyone is tested in their native language. This is to test the student's cognitive ability, not to base it on external factors. Parents must be notified and included. This must be done both verbally and in writing. Adaptive behavior is considered. Evaluate each child suspected of being in need. Preschool children are screened. This is done to be proactive so that going forward, every child's needs are met early. Evaluation must be in subject of need. Number 2, a team is formed to make decisions. One experienced team member in the area of need is on the team. Determination of special needs services is decided by the team. Individual Education Plan, IEP, is established. Goals and objectives are stated, and these are monitored and updated quite regularly. Placement. Appropriate education. Students are placed in the least restricted environment. This allows them to succeed without external stressors. Inclusion classes included that can assist or help the student's success. Inclusion classes are mainstream classes in which the special needs child is included to develop their skills and to motivate and to be part of the social setting. Any added services are also placed. Transition service. These are offered to students who have been receiving assistance in the school setting to continue with education and training in attempt to prepare them for a self-sufficient life. These trainings will be based on each individual and their set of needs. The Rehabilitation Act of 1973. There are two parts to this. There's the 504 and the 508. In the 504, this part of the act enables fairness and prevents discriminatory actions. This involves issues with either the mind or the body. Accommodations could include, but are not limited to, extended time, reduced assignments, study guides, and notes provided. In the 504, moved from Rehabilitation to the Workforce Act. Any technology that comes from government-funded programs must be accessible or interactive to allow those in need the ability to operate them in a non-discriminatory manner. The Americans with Disability Act. the Family Rights and Privacy Act, ADA. This act is meant to eliminate all discrimination and barriers. The intent is to offer support and opportunity to all individuals, no matter the severity, a means to have success. The act strives for equality, involvement, being self-sufficient. FERPA. This act sets for stipulations and limits on who is privy to student records. Parents have the right to access, react, and disagree, and the process used to act on disagreements. Also, it grants sole rights to the parents to release the student file. The act enables security and confidentiality. Special education eligibility, pre-referral intervention, an attempt by the mainstream teacher in classroom setting to make adjustments and find ways to increase performance within this setting. Some of these procedures are established and others are teacher-driven. Referral. A referral can be made by an academic stakeholder or the parents or guardians of the students. At this point, if the pre-referral process has already occurred, then a 10-day window opens to have necessary testing. Multidisciplinary team. This team consists of individuals from various aspects of the educational environment and the legal guardians. The team analyzes data and weighs all factors in determining if special education services need to be implemented. The process continues. Evaluation. Parents are notified in writing of intent to test, and they are given their rights as a parent in writing, documentation that rights were served, and acknowledgement of understanding. At this point, testing will begin to occur. Evaluation of services. Evaluations on presumed extended services are needed at this point, and the student is tested in that possible area of intervention. The team meets and reviews all these extra services and testing data. Triennial evaluation. Any student receiving special needs services must be reevaluated every 3 years in order to reaffirm, update, or check eligibility for special education services through IDEA. Evaluation and category of disabilities. 504. Tests must be given for their intended purpose and be valid in that area. Tests must be to an intended area and not for intended intelligence. Modifications are made to evaluate the student's understanding and knowledge, taking physical attributes out of the equation. Team consists of staff who have knowledge of the student. If parents question the testing validity, they may ask for independent educational evaluation, IEE, from outside sources. Categories. Attention Deficit Hyper Disorder, ADHD, falls under the need for evaluation. Based on the results and the committee, ADHD can be a 504 assisted situation. Learning Disabilities analyzes whether a student is below the ability of their age. This can include the current schoolwork and the end results relative to their age. There are numerous categories that fall under this heading of IDEA.